Surely.
A very good evening to one and all present here, enthusiastic participants, Pro Bono founder Dr. Kalpesh Kumar L. Gupta sir and Mohd Umar sir. It is my proud privilege to introduce the speaker for today. Mohd Umar is an accredited civil and commercial mediator by the Singapore International Mediation Institute and is presently associated with Samvad Mediation Center, Lucknow, as a consultant and trainer. He is recognized as a mediator by the International Mediation Institute, Netherlands, the world's top mediation standardization body, and holds a PhD from the Center for International Legal Studies, Jawaharlal Nehru University, New Delhi. A graduate of Hidayatullah National Law University and a gold medalist in LLM. Dr. Umar has given presentation in diverse areas of law and has reviewed, edited, and published in Scopus Index journals. Before transitioning into independent practice in 2023, Dr. Umar completed a semester course in conflict resolution at Harvard Law School, USA, and was engaged as a law academic for more than 7 years. His last teaching assignment was with the University of Lucknow, where he taught alternative dispute resolution, covering critical aspects of arbitration, mediation, out-of-court settlement, and the art of negotiation. Earlier, he had taught subjects like law of contract, family law, IPR, health laws, etc. Utilizing his experience in teaching, Dr. Mohd Umar has coached several stakeholders belonging to diverse backgrounds. He has adjudged several competitions organized by educational institutions and has been invited to train and speak at organizations by educational institutions like HAMS, London School of Economic and Political Science, Indian Law Institute, Kathmandu School of Law, and various national law schools. With this brief introduction, I, on behalf of JSS Law College and Pro Bono India, heartily welcome you, sir.
Yes, namaskar to everyone, and a very warm good evening. So, may I just have a check about the audio? Are you able to hear me properly?
Yes, sir.
Okay, wonderful. So I'm thankful to Professor Kalpesh for this opportunity and to the university for the for organizing this program where we discuss in depth insights about different topics like mediation, arbitration, and I was seeing that there are several topics which are going to be discussed. Well, the task that I have been given in this program is to speak on mediation. First of all, if I can just ask one of you to just give me what you think about mediation. If the audience can respond to that, what is the mediation in their perception? Anyone who would like to respond to that? No Googling, please, just your instinctive response. Anyone?
Anybody from the board?
Yes, participant, you can unmute yourself and then communicate.
Anyone?
Any participants?
Participant can unmute and can answer sir's question as to what is mediation. Sir, if we could answer from the boardroom,
Yes.
as to
Okay.
Can they do it, sir? Because currently they are studying.
Anyone?
Yes.
Anyone can answer. It's okay. If there's some difficulty in answering, then we will carry forward. But I would have really loved to know some opinion from the students, from the participants.
Sir, one answer from here.
Yes.
Good evening, sir. This is Ananya, and I believe mediation is a non-adjudicatory, non-judicial process of resolving disputes, wherein there's a mediator and the clients themselves interact with each other to sort out the disputes in an orderly manner.
Yes. So that is something that that is commonly perceived as far as mediation is concerned. Now, see, mediation is a semi-formal method of two parties coming to an amicable settlement with the help of a third neutral party who does not have the authority to impose the settlement upon those parties. This is a definition of mediation which is being taken from the Mediation Act 2023, and the section is Section 3H of the Mediation Act. Now, you must have noticed that I have mentioned the name of the act, which is the Mediation Act 2023. This is a fairly recent act which legalizes or rather legitimizes the mediated settlement agreement, which happens to be an outcome document of the two parties negotiating with the help of a third neutral party, which we call mediator. Now, can anyone tell me why do we have the Mediation Act of 2023? We already have court systems where people are getting their issues resolved. We already have a good amount of judges taking care of the cases before them. They are trying to give the decisions. In fact, all sorts of cases are being resolved. Criminal cases are being resolved. Civil cases are being resolved. Constitutional issues are being resolved. Then why this suddenly new method of dispute resolution, which we try to call mediation? What was the need for that? Can anyone instinctively respond to this? Why do we need Mediation Act? Anyone who can try to do this? Before being a trained mediator, I'm a trained teacher. So my instinctive response is to take opinions from the participants.
For
So if
peaceful
yes,
settlement of issue.
okay, madam, peaceful settlement of disputes. So is the dispute resolution within the courtroom, is it not peaceful? Is it violent?
It is time consuming process.
Yes. So now we are getting there. So one of the reasons why we got to mediation or why we thought that it is important to have an alternative dispute resolution arrangement like mediation was because courts were taking too much of time. There was a lot of time being consumed by the courts. In fact, I would suggest you, there is a New York Times article 2023, which says that at the given pace, the pace which the judiciary is resolving the disputes right now, it would take another 300 years to clear the backlog. If no new cases are filed, by the way, if only the present cases are supposed to be resolved, it would take another 300 years for the courts to resolve the case. Imagine the kind of plight that we are destined for if we are not able to think of some creative dispute resolution techniques. Any other reason? All right, so one reason why we need mediation is that courts are taking a lot of time. All right. Any other thing that you would like to mention? I think there was some response in the chat box.
Speedy remedy.
Speedy remedy and time taking, both these comments are time centric. So let us take it in a same stride. But yes, I think Srirang has said something in the chat box. Yes, now we are getting the responses. So Professor Kalpesh, would you help me with the responses one by one? Can you help me with that?
Yeah, sure.
Yes, please.
Second,
The first, I think we can start from Srirang.
yeah, so Srirang, it's a win-win situation for both parties.
Yes. So let us discuss this. Let us pause and discuss this. See, in litigation or in arbitration, what is happening, what is getting discussed. Write down in your notebooks if you have the notebook before you. In both litigation and arbitration, law is getting discussed, right? Law is getting discussed, and at the end of the process, whether it is litigation or whether it is arbitration, only one party is winning. One party is winning, and the other party is losing. So there would always be one party which would be an aggrieved party who would dislike the outcome, right? And then there would be attempts to, get it revised, reviewed, or appeal, and all those things that are available for the legal practitioners. So arbitration and litigation are, please write it down in your notebooks, they are adversarial process. Adversarial process, and in mediation, we are talking about non-adversarial process. Perhaps Ananya, when in the beginning she said non-adjudicatory, she meant non-adversarial. See, adversarial process, now just to talk a little bit about this, adversarial process presumes that there are two adversaries fighting with each other. That is why we have the term adversarial process. Non-adversarial processes where the parties are sitting with each other, talking it out, reasoning it out with each other, negotiating so that they have a mutually agreed outcome, which we call as mediator, we call it settlement. Right? So that is a very important reason why we had the Mediation Act. Because now more and more corporates, more and more parties, they are looking forward to a settlement rather than a prolonged judicial process or other forms of adversarial processes. Then after that, we had another response from, I believe, Raj Singh. Yes, Mr. Raj, this is a less costly process, a more economical process, because the outcome is guaranteed within 6 months, right? So that is the maximum time. In fact, it is 4 months plus 2 months. So 4 months is the original time where the outcome is guaranteed. Whether you settle or you don't settle, but you have a clarity about the dispute, right? And it is happening on a much less cost basis than before. Because in litigation, what happens, let's say if the case goes on for minimum 15 years, that's the average time that any case would take, it would consume too much of money for the client. It would consume the lawyer's fee. It would consume the conveyance fee, client going to the venue, going to the courts, coming back. It would consume the court fee, and of course the mental piece. How would you monetize that? That has no, monetary evaluation. So yes, compared to that, mediation happens to be a much more cost-effective method, right? So win-win we have covered, cost process we have covered. Manisha is saying victim-oriented. Manisha, can you talk about that? What you mean by that? Something being victim-oriented? If you have Manisha over here, because she responded on the chat.
Yes, Manisha, are you there? Or you can elaborate in chat box if you don't want to unmute yourself.
Okay, you can put it in the chat box. Meanwhile, let's see if what Anurit has said. Anurit is saying that mediation process is more confidential than court proceedings. In fact, to make it slightly tweak your statement, mediation process is the most confidential process amongst all the dispute resolution processes available. See, in a court of law, you are watching your dirty linen in public. You are a subject matter of gossip. Lawyers are listening to you, other clients are listening to you. So your family disputes, your sensitive commercial disputes, it is all out there in public. If you are a high profile person, maybe you will get a space in the newspaper also, but not for good reasons. right? So mediation offers you something very basic, which is confidentiality. It is one of the pillars of mediation. We will talk about pillars of mediation eventually, right? I think Mr. Nagendra Murthy want to say something?
Sir,
Yes, sir.
please continue, sir.
Okay, okay, no issues. And the other thing that Anurit is saying that mediation is satisfactory and durable outcome for both parties. Yes, so that we have been discussing that when you arrive at a mutually agreed solution, it happens to be a satisfactory solution for both the parties. Both the parties are having a win-win outcome and they move on in their lives. See, one of the basic things about mediation is always forward looking. While on the other hand, litigation is always backward looking. It is looking back that on that day you did this to me, on that day this happened. Mediation is what would happen if we resolve this? What are the opportunities that we have? So mediation is always forward looking, right? Then we have the next, one of the most important reasons why people are choosing mediation now is, and I'm sure all of you would agree, that in litigation or in any adversarial process for that matter, the relationships are at stake. People are fighting with each other. They are, the moment, imagine a husband filing a case against the wife in a court. Would the relationship sustain after that? This is one question that I ask you. Imagine a brother fighting a court case against his brother with regards to property. Would that relationship sustain after that? Imagine there are two companies who have been working with in very close quarters, then suddenly a dispute arises and they go for litigation again. Would they be able to sustain it? Now, this is something that we need to acknowledge that as far as mediation is concerned, in mediation, the relationship is at the heart of the issue. Parties are always implored that they should think about their relationships with each other, the benefits that it can accrue to each other. So, husband and wife remain cordial to each other, brothers remain cordial to each other, sisters remain cordial. Companies are still closely, working. So the relationship is extremely, extremely important and it is maintained in mediation. Another reason why we have a mediation act or why there is a thrust towards mediation, there is more and more people going towards mediation. In fact, I would like you to Google in your own time and space two news items where Chief Justice of India, the ex-Chief Justice of India, Justice D.Y. Chandrachud, is making a statement that people are fed up with the judicial process. It is in fact a brave thing to say for a Chief Justice to acknowledge that judicial system is now a harrowing experience for people, right? So he's saying that people are fed up with judicial settlements, processes, and they want to go for settlements. Look out for the news item where a person goes before the Karnataka, I believe the partner college is from Karnataka. Look out for the news item where a person goes before the Chief Justice of Karnataka High Court and slits his throat before the Chief Justice. Why? Because one of his cases was taking too long to resolve. It happened within the premises of Karnataka High Court, right? So one of the reasons for all of this is that people are now slowly realizing that litigation, or even for that matter, any adversarial process, is not something which should be, practiced. And one of the reasons for that is that there is an issue of, how would you put it? There is an issue of rigidity. in legal systems or in arbitration where only law is discussed and there is no emotion or no flexibility available, it is all about law and rigid legal processes. But in case of mediation, you transcend that rigidity. I have done two mediations, one sitting in a coffee shop in a closed, space of a coffee shop. There's another mediation that I have done in my own house, in my house setting, in a general hall setting, with a very, very, relaxed environment, non-intimidating environment. Imagine a common person going to the courts, looking at their lordships with black robes on, with all that intimidating furniture, and order happening, and people's name are being called out, and police is present in the campuses. It's an intimidating process. Parties doesn't feel heard. They are not the center of the law, of the discussion. In mediation, parties are the center of the discussion. What litigation cares about is only law. So with all these things combined, what is happening? People are resorting more and more towards mediation. Mediation Act is one of those few legislations where you will find the sanction for online dispute resolution like never before. There is no jurisdictional boundary. You can write down in your notebooks if you can, Section 13 of the Mediation Act says that you can choose to transcend your jurisdiction, the territorial jurisdiction, by the agreement of the parties. Right now, I am doing a case sitting in Lucknow for the parties in Madhya Pradesh, and it's all going online. So we have all those online tools, flexible tools, where parties can get their matter resolved in a speedy way, right? So we tell how mediation happens in great detail in our training programs also. But as of now, this is supposed to be a 1.5 hour or so duration lecture. So I would like to highlight few broad points about mediation. But before I go there, people, I want to ask you one thing, that we have been harping on the situation that the Mediation Act 2023 has come. The Mediation Act 2023 has come. It's a new dawn in the era. It's a new opening of vistas for dispute resolution, etc., etc. Why it has come? So we have been talking about that till now. But my question to all of you is, do you think that mediation is a new process, or has it been a part of our culture, of our tradition since the since the beginning? Can you tell me?
May I say something?
Yes, ma'am. Please go ahead.
Mediation was part of our culture because we can see the examples of panchayat, which was always there in rural areas, because the family disputes related questions and basically husband-wife or brother-related disputes were all adjudged by the panchayat, sarpanch, and other related elder family members. So mediation was there from lies in our culture from the beginning.
Okay. So let us see if panchayat is. Yes.
Sorry for the interruption. Can I answer, sir?
Yes, I would just come to you. Just give me a moment. I would come to you. Let's see what Miss Mamta was saying. Mamta was saying that panchayats were a form of our mediation processes. Well, did panchayat work as in a non-adversarial setting? That we have to ask a question. Because in panchayati system, what happens is there's one person sitting in the authority to give a decision. In many instances, it is not a party-generated outcome. It is not a party-generated outcome, right? So that's why we can't fit in panchayat system into a traditional mediation format. But a good attempt. It was nevertheless a system which was, happening out of the King's Court or out of the adversarial processes set up by the British. So I would give you some points for that, but it we have better examples. So yes, I think someone was responding to that. Yes.
From the boardroom, myself, Asmuthanisa, Assistant Professor of JSS Law College, sir.
Yes,
Sir,
madam.
I have read many articles on ADR since I'm holding subject for my students. So
Yes.
as far as that particular, my limited knowledge on this particular aspect is concerned, earlier in traditional India, we had certain systems like Kula, Shreni, Puga, and also
Yes.
kings used to take the help of their amatyas, which were called as their eyes. For example, Birbal was one of the good mediator. So
Yes.
if I'm not correct, please rectify if I'm wrong, sir.
You are absolutely correct. In fact, the Law Commission of India report clearly documents this, that we had all the kind of out of the King's Court settlement mechanisms. Like you mentioned, Pug, Shreni, Kul. So these were not just community mediation programs, they were individual mediation programs, they were commercial guilds. What is Shreni? Shreni is nothing but a commercial guild being formed to settle commercial disputes. So it has already been a part of our society, but nevertheless, then we shifted towards the adversarial process introduced by the British, and since then litigation has just taken over. So our memory of our traditional resolution of dispute has faded away. In fact, that's a part of our culture. In our household system, we have concepts like karta or the head of the family who who usually mediates or strikes a compromise between the conflicting parties. But all of that is getting dissolved. Families are breaking up, and then people are resorting more and more towards litigation. So that is one thing that we are facing right now. I think there is someone who has written something in the chat box. Srishti.
Shall I read, sir?
Yes, madam, please.
In my opinion, not only in Panchayat, in every household, older people or karta or
Yes.
a great mediator.
Yes. So I just mentioned that our family structure is like this, that we have seniors mediating the conflicts amongst the junior members of the family. So this is not something which is new. Also, I don't know if you have read this poem by Ramdhari Singh Dinkar, Krishna Ki Chetavani, where when Sri Krishna goes to Duryodhan and has a discourse about giving just 5 villages and keeping rest of the kingdom with himself, Duryodhan denies that. Sri Krishna tries to convince, but Duryodhan still denies it, and then finally it leads to Mahabharata, the biggest war that we have seen, right? Because what happens in litigation? In litigation, your egos are inflated, right? Your egos are inflated. That put this section also over there, put that section also over there. And then finally, the parties are in absolute conflict. And that is what Ramdhari Singh Dinkar says in his poem in Hindi. I'll just translate that for you. It basically says, "जब नाश मनुज पर छाता है, पहले विवेक मर जाता है." When a person is doomed, his or her ability to think just fades away. So this is what litigation does. It diffuses your ability to think rationally, because then your ego is so inflated, right? So these are some of the things that we need to understand. See, why the other reason why mediation is having a one-up with all other dispute resolution mechanisms. One is that mediation gives you the option of being creative. It gives you the option of being creative, generating options other than what law has to offer to you, going beyond the legal solutions. So, for example, I would like to share one story with you. Just give me a moment. I will connect the Blackboard and I would like to share one example with you how mediator is supposed to behave. Just give me a moment, okay? Yes. So I will share the screen with you. and we will go along with this story. Again, the only request I have from you is please don't open up Google, otherwise it will spoil your experience. Just be in the moment, and it would be really good, thing to have. Can you all see the Word document opened up? Please let me know.
Yes, yes.
Okay. If you all can see the Word document open up, so the story goes like this. So there was this person who had, person P, he had 3 sons. Let us say the eldest son was son E, the middle son was son M, and the youngest son was son Y. So this person was a person residing in the Thar desert of Rajasthan, and it was really important for them to have camels. They don't have much of the properties as such in terms of land, because what would they do by owning the lands over there in the sand dunes? So their properties are cattle. Their important properties are cattle. So this person P has 17 camels. It has 17 camels, and he decides that, see, I've got old now, and I need to make a will for my son so that I can die peacefully and there is no dispute with regards to the properties after my death, right? Then what happens? P makes a will. I hope what I'm writing on the screen is clear to all of you. I have increased the font also. So person P makes a will. And in making this will, what happens is person P gives certain shares to these 3 sons. So the eldest one gets half of the total camels. Eldest one gets half of the total camels. The middle-aged son gets 1/3 of the total camels. And the youngest son in the will gets 1/9 of the total camels. Eldest one gets half of the total camels. The middle one gets 1/3, and the youngest one gets 1/9. So now my question to you is, how would you divide 17 camels between these 3 sons? Do you have any resolution? Do you go to the courts? It's difficult to have a formal court system in a in a in a setup of a desert. So they don't have an option to go to the court. The only option they have is to fight it out with each other or get it resolved by someone who is having a mediator's mind. So anyone who would like to suggest what happens in this kind of a situation? I would repeat the problem for you. So a person P leaves behind 17 camels, and in a will he gives half of those camels to the eldest son, 1/3 of those camels to the middle one, and 1/9 of those camels to the youngest one. Now, how do you divide 17 camels in this proportion? Is it possible to divide them in these proportions? First of all, tell me.
Yes,
Can you give?
sir. If
Yes.
the minister gives his one camel, then the total of the camel will be 18. So 18 by
Ah,
29 and 18/3 will be 6 and 18/9 will be 2.
that's a brilliant suggestion. So may I know something more about you? You are from which college?
Nainita from 6M LLB.
6M LLB. Okay, great. So what Nanita is saying that these people will go to the mediator, and what this mediator will do, mediator would say that you do one thing, take my one camel, okay? Take my one camel and add it to your 17 camels, and then try to make a division. So now the total number of camel becomes how much? Total number of camel becomes 18. And now it is easier for the eldest one to get half of these camels, which happens to be 9. and the middle one gets 1/3 of these camels, which happens to be 6, and the youngest one gets 1/9 of these camels, which happens to be 2. So how many camels are getting divided now? 9 plus 6 plus 2. This is coming to 17 camels. So now they have successfully divided these 17 camels. And how many camels remain out of these 18 camels? One camel is out of this. And this one camel anyway belonged to the mediator. So the mediator takes it back, resolving the dispute between the brothers. This is what we mean by, very important thing, this is what we mean by generating options in mediation. Now, you will not find this kind of a solution in a litigation setting, in a legal setting. You will not find it, but you will find it only in mediation, thinking out of the box. Right? In fact, what happened was there was this very famous case in mediation that happened. Just to give you a point about what generating options, the power of generating options. So there were two conflicting parties. One party was involved in an act of piracy. I hope all of you understand what piracy means. So what happened was that there was this person who was manufacturing jeans with Levi's logo on it, right? And he was manufacturing those jeans with Levi's logo on it without due permission from the company. So, so I want to ask you, is there any law getting violated over here? When a person uses the logo of a particular company without the authorization from the company, is there any law getting violated over here? I can't hear you. Yes, yes. Anurit, Manisha, Nikita, they are saying that there is a law getting violated over here. And the law that is getting violated is trademark, because you have not taken the permission from the company to use the logo. Now, the company, of course, sues the person. Yes, Lokesh, it's trademark is a form of intellectual property, right? So the person gets sued by the company that how come you are using my logo and making money out of it, selling it off as if it's a Levi's jeans when it is not. So the matter goes to the court, and the court refers it for mediation. You know the question that mediator asks the company person: have you seen the jeans that is being manufactured by this person? He says, yes, I have seen the jeans. They are using the logo wrongly. So mediator says, see, I know that they are using the logo, but have you seen the quality of the jeans? How's the quality of the jeans? Right? So the mediator, so the jeans representative says that the quality is pretty good, but doesn't matter if the quality is good or not. They are violating our trademark rights by using our logo. So therefore, we want to sue them. It is costing us money. So mediator then asks the second question: are you looking towards expansion of your market in Delhi NCR? So the answer is an affirmative, that yes, we are. And do you need people to supply you good quality jeans which you can put up in the market? They said yes. The last question that mediator asked was, with the quality of jeans that this person is manufacturing with an unauthorized logo, can you think of hiring this person who will give you the supply of jeans at a lower cost so that you can expand your market? He thought over it and he said that this is a great idea. Why not? Why not have it? Right? And what happened was that the company which was suing the person for piracy, for using the logo in an unauthorized manner, it ended up hiring that person for the purpose of supply of good quality jeans, and it expanded its market and made money out of it. So this is the power of mediation that it can turn the conflict to collaboration. If you want to write it down, please write it down. Mediation has the power to turn the conflict into collaboration. Unlike any litigation, which can turn the conflict and keep on snowballing it to the extent of absolute animosity between the parties. I hope what I'm saying is making some sense to the listeners. Please let me know if you are with me till now, because I can't see anyone, unfortunately. Are you with me?
Yes, sir.
Yes? Okay, wonderful. So now we come to the next important point, which is what are the key aspects of mediation? Now, let me open up the Mediation Act for you so that I'm able to explain this better to you. Just give me a moment. Yes. Please let me know if you're able to see the Mediation Act before you.
Yes, yes,
Yes.
yes.
Okay. Okay, wonderful. See, the Mediation Act is supposed to be done in accordance with Section 15. And let me take you to Section 15, which talks about the conduct of mediation, how mediation is supposed to be conducted, right? So, yes, our focus should be over here on clause 2 and clause 3 of Section 15, right? Can anyone help me with reading the first clause, that is Section 15, clause 2? Can you tell me?
It's done from Bodo.
So the mediator shall assist the parties in an independent. The mediator shall assist the parties in an independent, neutral, and impartial manner in their attempt to reach an amicable settlement of the dispute.
Okay, just hold on. So we pick up three things over here: independent and neutral and impartial. Independent, neutral, and impartial. So all of this combined, we simply call it neutrality. So neutrality is one of the most important pillars of mediation, right? Neutrality is one of the most important pillars of mediation, where a mediator cannot be biased towards any of the parties. If the mediator knows any of the parties since the beginning, or for any transaction that might have happened before the mediation, the mediator needs to disclose it in writing. That disclosure is important and it is mentioned under Section 10 of the Act. All right. So neutrality happens to be the first principle of the conduct of mediation, right? Then we come to the clause 3 of Section 15. Can anyone help me with this? Someone other than who just spoke? The mediator shall at all times, come on.
The mediator shall at all times be guided by the principles of objectivity and fairness and protect the voluntariness, confidentiality, and self-determination of the parties and the standards for professional and ethical conduct as may be specified.
All right. So how is the mediator supposed to conduct herself or himself? The mediator must be guided by the principles of objectivity and fairness. So this is a general prescription, and it is applicable to anyone who is sitting in a position of, a little bit of, settling the conflict. So you have to be guided by the objectivity and fairness, and it is a voluntary process. Mediation is always a voluntary process. You cannot hold the parties by their collars and make them sit and say that you have to mediate. What happens in litigation? Once you serve a notice, the case starts. It is triggered now. So unless and until the party who has filed the case takes it back, till that point of time, you have to abide by the summons, you have to abide by the appearances, court fee, and all, and whatnot, right? Otherwise, ex parte order will come against you if you will not cooperate. Isn't that so? So we have lawyers and law students over here. So am I speaking the correct thing? There is no element of voluntariness in mediation. in the case of litigation when mediation is extremely, fully voluntary. Then look at the second thing, confidentiality. I've already told you that confidentiality is a pillar of mediation. Every communication that is happening within the mediation is supposed to be protected, and none of that can be used by the parties against each other in a court of law if they don't settle. So voluntariness and self-determination, we take it together and we simply call it self-determination. That there has to be no element of coercion or undue influence upon the parties when they are called upon to mediate. It should be completely by their free will. It should be completely by their own volition that they come to discuss their matters out. Right? So this is how you are supposed to conduct mediation settings. And of course, please remember, mediation settings are not intimidating settings. They are rather intimate settings where you are sitting in a relaxed environment with parties, trying to listen them actively and trying to helping them out, trying to generate options, and then finally leading them towards a positive mindset from their lizard brain to their wizard brain, and then finally getting them resolved. It is not that the mediation is always successful. So a lot of things depend on a successful mediation. The parties need to cooperate. The parties need to come with a right mindset. They should not come to the mediation with a mindset of abusing the process or delaying the process further, that it's okay, it would take another 6 months to discuss mediation and then we will go back to the court. So that is a wrong mindset for mediation. And that is an unhealthy mindset for one's own self, because you are only getting involved in litigation. Right. So self-determination, neutrality, and confidentiality happen to be the three most important pillars of mediation. Now, what is the mediator supposed to do? So tomorrow, let's say if you attend a training program by Samvad Mediation Center where you become, you become trained mediators, and we make it sure that you get training in online dispute resolution. We make sure that you get training in all latest formats of mediation, covering all latest disputes. Let us say that you become mediator tomorrow, right? What is the next thing that you would do? The next thing that you would do is to practice this, what is mentioned under section 16. So there are 4 or 5 elements under section 16 that we all must be aware of. See, mediator is a voluntary resolution of dispute. We have already done that, right? Where the first thing that the mediator is supposed to do is communicate the view of each party to the other. So what one party wants, what one party thinks, is communicated to the other party via the mediator, right? Communication is an important aspect in mediation. So a mediator is supposed to be trained in that. How to communicate, what to do. So what happens is, let us say that if there's a dispute between husband and wife, and the husband is saying that my wife throws shoes at me, right? Hits me on my face. So you can't say to the husband that, oh, this is a horrible thing that your wife does to you. Oh, she is such a wrong person to be with. So things like this, you're not showing sympathy, a constructive, you're not showing a constructive communication. You're making things worse, right? You're making things worse. So your communication should be effective. It should be in a direction that takes the things forward in a positive way, right? So communication is the first thing that the mediator is doing. The other thing is, mediator is assisting them in identifying issues. So imagine the captain of the ship, the mediator herself is assisting the parties in identifying the issues, that see, sir, this is something that you have been facing, and can we say that these are the issues that are central to your problem, or if you want to add some more issues to this. So the parties are having complete freedom. In a court of law, what happens? Who decides the issues? Can anyone tell me who decides the issues in a court of law?
Judge.
Yes, the court decides, right? The parties don't decide. Over here, the mediator is helping the parties in identifying the issues. Like, you tell me the real issues. Otherwise, if you go before the judge will frame it according to the law. If it's a title dispute, it has to be a title based issue. What emotions go behind that title dispute, no one is caring about. What interest is going on behind that title dispute, no one is caring about. Right? So, that is something that we need to understand. Advancing better understanding. So, the mediator is supposed to be the bridge between the two parties, right? Clarify their priorities. So, there might be many small little things. It happens in family disputes many times. So, one mediation got resolved only by the act of the son touching the feet of his father. There was a conflict between father and the son, and all those little things just went, in the background when the son showed the respect to the father that father was, expecting. So the priority over there was the father was feeling the lack of respect. How would a law articulate respect? Can the law articulate respect? That you should be, party A should be respectful towards party B. By what law would the court say that? So that is something that mediation does. Advancing better understanding, clarifying properties, exploring areas of settlement, and generating options, right? And always putting the spotlight on the parties. Now look at this over here, what mediator is doing, or what mediator is supposed to do. Mediator is emphasizing that it is the responsibility of the parties to take a decision regarding their claims. If you want to write down one sentence from this session in your notebooks, I would request you to write down this sentence, what I'm going to say. Mediator is in charge of the process, while parties are in charge of the outcome. Mediator is in charge of the process, while parties are in charge of the outcome. The job of the mediator is to administer the process. So in our training programs, we tell you about each step. So the next one is going to happen in June. If you're interested, feel free to contact us. It's samvadmediation@gmail.com. So mediation takes care of the process. For example, the opening statement, the exploration stage, the negotiation stage, and then finally the closing stage. These are the 4 stages that we train the people for good 2 to 3 days. So once you administer that process, once you master that process completely, it is left to the parties to decide. It is ultimately the parties' decision. At any point of time, parties can choose to walk out of mediation. Unlike litigation, parties can always choose to walk out of mediation saying that this is not working for us. This is the leverage that parties get in the case of mediation. See, till now, what mediation was, a mediated settlement agreement was having a force of a contract, right? So it is as good as a contract. It is drafted in a format of a contract with all those things considered, and it had a force of a contract. But Mediation Act changed a lot of things, right? So let us see the big bang change that the Mediation Act has brought to the dispute resolution. Can all of you see section 27 on your screens? Please let me know.
Yes, yes.
Yes, sir.
Okay, wonderful. So look at this. Long story short, section 27 clearly says that Mediation Act will be enforced as if it is the judgment or a decree passed by the court. So now the outcome of mediation, the degree of outcome of mediation is elevated much over and above the outcome of a contract, a settlement contract. Now, whatever mediated settlement parties are signing, it would have the force of a judgment or decree passed by the court. Right? So this is something that we need to understand that now mediation is getting very, very serious. It is now having a force of a decree of civil court. So it is much more authoritative than before, much more enforceable than before, and parties from henceforth would take it much more seriously. They should have already taken it seriously, but now with the emphasis of mediation outcome document being enforceable, it would be a much more forcible document. The last thing that I want to mention, so one of the unique features of the Mediation Act I mentioned was that the Mediation Act promotes online dispute resolution with no bar of territorial jurisdiction. I have already mentioned this point. The other point that makes Mediation Act unprecedented, unlike any other legislation, and again, it's a kind of an acknowledgement of the power of mediation. See, India is a diverse country. We are different communities, different languages, culturally different, religiously different, lingually different. So there are so many things, dialectically different, racially different. So India is the most diverse country in this whole world. All of us agree with that. So with so much of diversity, it is quite natural to have conflicts. But sometimes conflicts can blow out of proportion, right? It can lead to violence, it can lead to deaths. It is a sad story. We have our own episodes in our history, and all of those are very, very sad episodes. One of the things that came in the legislature's mind was that perhaps the most effective method of diffusing this kind of a communal tension can be through striking a mediation, a preemptory mediation. And that was captured in this section. If you're able to see this on the screen, can you see community mediation on the screen?
Yes, sir.
Okay, look at this. So it is saying that any dispute likely to affect peace, harmony, and tranquility amongst the residents or families of any area or locality may be settled through community mediation with the mutual consent of the parties. In fact, this was attempted by the court in the Ayodhya case. It failed, and so the point that I'm trying to make is that mediation is something which is the first choice of the greats in our history. Shri Krishna tried to strike mediation. In Ramayana, you would go, Angad tried to do mediation. Jesus Christ said in the Bible that blessed are those who strike peace, who make peace. Prophet Muhammad has many instances of mediating between the two communities and striking a very healthy compromise. So all the greats in our history, they have attempted mediation. Today, we are recognizing the power of it. We are fed up, speaking in the terms of the ex-Chief Justice. We are fed up with the judicial process, and we now want desperately to have settlement. For those of you who have been into litigation or who have been lawyers, you would realize what I'm saying. For those of you who are teaching or learning law, you must acknowledge this fact instantaneously that all the high ideals that we teach the students in a classroom setting, the practical reality is something very, very different, and it is not working out for the parties. Everyone in every quarter realizes that. The only antidote to this clogged judicial system is having a healthy culture of mediation. And that is something which is a sine qua non for our dispute resolution mechanism. If you want to have a healthy dispute resolution mechanism, a healthy culture, lesser cost of conflicting parties, and a developed and a Viksit Bharat, then perhaps mediation is the only way out. I would stop here and take a few questions. If any one of you are interested in asking any question, I would be most happy to respond. Thank you.
Hello, sir. This is Pratham Punacha from 6M LLB JSS Law College.
Okay. Yes.
My question is that some of the parties, they are egoistic, and as you mentioned that voluntary and confidentiality is the pillars and the main objective of mediation. So if the parties are not willing to abide in good faith, so as a mediator, how will he play his role in solving the dispute peacefully and amicably?
See, in our training programs, we teach you how to break the impasses, right? So sometimes there's a deadlock between the parties, right? They are not moving forward. So there are some techniques that we make you practice for the purpose of breaking the deadlock. And we try to, remind the parties that, see, if you opt out of mediation, then you're losing the seat of power. You're losing the seat of power, and you are going to be subject to a system which would be only concerned with litigations or legalities, and your own concerns, your own interests will take a back seat. So this is your only opportunity where your interests are at the forefront. So are you really willing to let it go? There are several other things that we ask. So it's also psychological. We try to do few things psychologically so that the parties remain in mediation. And ultimately, see, it's the call of the parties. If despite your attempt to help the parties, to remind them that they would lose the seat of power, if still they want to choose to go out of the mediation, they are free to go. And they have anyway paid you the fee. So it is not a big loss for you. But then as a mediator, you should, as Section 16 says, create or strike better understanding between the parties. All right.
Yes, sir. Thank you, sir.
Yes.
Good evening, sir. I'm Nainata
Hi.
from 6M LLB of JSS Law College.
Yes. Hi.
So my question is, as you've already mentioned, that this act recognizes online mediation. So,
Yes.
given this digital divide issues and data protection concerns, like what regulatory framework do you foresee being required for safe and effective virtual mediation? That is, like, how does the act accommodate the rise of online mediation, and is there any data protection or consent, like safeguards built to this framework?
Yes, see, the provisions of Digital Data Protection Act or and the provisions of the Information Technology Act, they would apply in a mediation setting too. And it is the job of the mediator to remind the parties that, see, at all costs, we have to maintain confidentiality. And this is one concern that is there in an online setting. So let's say if we are having an online mediation, so the parties can simply open their phones and record, keep the phones on the side of the laptop and record the entire proceeding as it is happening. But if the parties do that, it is the violation of the confidentiality provisions of the IT Act, of the Data Protection Act, and therefore this can be something which can be conveyed to the parties beforehand. So I hope that answers, right? So you need to make the parties data literate if you're doing an online mediation beforehand, and at least ensure, at the minimum, ensure that they are following confidentiality and they are respecting the privacy of each other. Yes. So that happens because it is the job of the mediator to do this. It is the responsibility of the mediator to conduct the process. Remember, mediator is in charge of the process. Parties are in charge of the outcomes. So the process is in your hand. You are the captain of the ship. So how would you take it forward? Ensuring that there is healthy confidentiality mentioned, ensuring that there is no obscene exchanges on a screen. This is something that the mediator has to ensure, right?
Thank you, sir.
Okay.
There is a question in the chat box, sir. Can mediation be taken up in criminal matters as well?
The short answer is no, because the first schedule of the Mediation Act says that criminal offenses cannot go for mediation. A more detailed answer can have two legs to it. One is that the Mediation Act itself acknowledges that non-compoundable offenses can go for mediation with the permission of the judge. So it is not a stricto sensu formula that the mediation is supposed to be only applicable in civil disputes. So non-compoundable offenses by law can be referred for mediation. The other larger question that we should ask is, even if it is a compoundable offense, which happen to be serious offenses, why can't we have mediation for that? Why can't? Why not a mediation even in compoundable offenses? So we go into the debate that a criminal offense is a crime against the state, it is not a crime against the individual. But of course, we can make some concessions. What is plea bargaining? Plea bargaining is again a form of negotiation, right? Ultimately, it is kind of bargaining about reduction of your sentence. What is blood money in West Asian jurisdictions? So if someone murders someone, the victim's family is offered some money, and if they take that money, the person is forgiven. So even in heinous crimes, we can imagine the application of mediation, and there are several books written on it. I am not recollecting the titles of the book right now, but this is something that needs to be discussed and debated, and it would come to India also. Right now, crimes cannot be mediated, only non-compoundable offenses with the permission of the judge. I believe Section 6 of the Mediation Act allows for that, right?
Sir, there
Okay.
are
Another question: which are the issues that are mostly dealt in mediation?
Which are the issues?
That are mostly dealt in mediation.
Civil cases, and it depends on what kind of a mediator you are, which expertise you are having. Are you having expertise in intellectual property? Are you having an expertise in family matters, in contractual matters, so in real estate, in consumer matters? So it would also depend on your specialty. But one good thing about mediation is that mediation does not require a hyper specialization, that you must be an expert in a real estate dispute, only then you can be a mediator. A functional knowledge of any system is more than enough. It is more than enough, right? What you need to do as a mediator is to master the process. If you have mastered the process, you can mediate any kind of a dispute with a functional knowledge of that area, right? Yes.
Okay. Another question: can the decree of mediation is binding on the parties, and it can be further challenged?
Yes. So the answer is yes to both of those questions. So Section 27 we just did, that the mediated settlement agreement is having a force of a decree of a court, and it has very limited grounds of challenge. See, Arbitration Act is having Section 34, which is almost an essay. I think the professor from the law college would acknowledge that it is almost an essay. Section 34 gives you so many grounds, including vague grounds: patent illegality, public policy, and not following natural justice, and all of that. But mediation makes it very specific. There are 4-5 grounds mentioned under Section 28: fraud, corruption, impersonation, and that's it. So there are very limited grounds on which the mediated settlement agreement can be challenged. Uh, and yes, that's the case. It can be.
Okay. What are the qualifications required to become a mediator?
Well, there are in India right now. We are supposed to have a body which is again created by the Mediation Act, which is Mediation Council of India. So that would come. I don't know when it would come, because Arbitration Council of India was suggested in 2019 amendment. So
ವ್ಯಕ್ತಿ ಅಂತ ಹೇಳ್ಬೋದು. ಬಟ್ ಅಜ್ಞಾತವಾಸಿ ಸಿನಿಮಾ ಸಿಕ್ಕಾಬಳೆ ಇಂಟ್ರೆಸ್ಟ್ ಇದ್ದು ಈ ಸಿನಿಮಾ ಬಗ್ಗೆ ವಾಪಸ್.
Okay. So in Arbitration Council of India is not yet formed. So it was supposed to be formed in 2019. After 2019, it is yet to be formed. Now, Mediation Council of India would come, I don't know when. So what people are doing, there are two things that are happening. One is that people are mediating on the basis of Arbitration and Conciliation Act, because that is the operative law by the time Mediation Act would come into force. And number two, people are taking international qualifications and getting themselves trained as a mediator, because under Conciliation Act, you're not supposed to have any qualification. You're just supposed to be the choice of the parties to mediate. So this is how things are working out right now.
Okay. Should mediation be made mandatory before filing a civil suit in court, or should it remain discretionary?
Yes, that's a tricky question, because I have been telling you in this entire session that mediation is voluntary. Mediation is always based on self-determination. But see, what happens is that mediation sometimes is mandatory in nature. For example, Section 12, capital A of the Commercial Courts Act says that before you come to the court, you must mediate. So that's a mandatory requirement by the court. Now, as a mediator lobby, we say that the court should not arm twist the parties to mediation, because then they will not go for a healthy with a healthy mindset. In fact, in the beginning stage itself, the court can recommend that this is also one option you have. Would you like to try this? If the party says yes, then they can go for it. If the party says no, then the court should continue, because ultimately making the mediation mandatory would breach the aspect of self-determination and voluntary, which is the pillar of mediation.
Sorry, I have muted, so please. Yeah. So, sir, can there be more than one mediator in the mediation to resolve the dispute?
Yes, we can have. So there can be co-mediators also. But not many mediators. I think what we do is we don't have more than 2 mediators if required. Otherwise, it is mostly a sole mediator who's taking care of things, because that gives a certain uniform direction to the process.
Okay. Whether mediation be referred when there are more than 2 parties, like partition matters? More than
Why
two.
not? Why not? Multi-party disputes can always be subject to mediation, and it just requires the consent of the parties. So if the parties give a consent, then why not?
Okay. Can the court transfer a case for mediation?
Yes, courts do that. In fact, family courts do make sure that the cases go for mediation, and same with the commercial courts. So almost all the high courts in India have court annex mediation going on. But the issue over there is that all those mediations are being done by the lawyers. So a lawyer is having an adversarial mindset. We are trained in escalating the issue. We are not trained in de-escalating the issue. So I don't know how much of that is functional and how much of that is really giving constructive, sustainable output. Because a lot of court annex mediation happens to be, just a formal, step in advancing the mediation. I know many cases where parties abuse the court annex mediation processes in order to just delay or take out the confidential information from the other party. So that should not be happening. But yes, court annex mediations are happening in the high courts. Sometimes in district courts also, they have mediation cells.
Thank you very much. Over to boardroom.
Any other questions from the participants from the boardroom? Okay, sir, with your permission, can we move on to the last session by proposing vote of thanks? Sir, Kalpesh,
Yes,
sir?
madam, please.
Thank
Yes, at your disposal. Yes.
Good evening, everyone. I am Sahana BHM of 10th semester BBA LLB, student of JSS Law College. I take this opportunity to propose vote of thanks on to the second session of the 10-day online capacity building program on ADR, legal aid and allied laws jointly organized by Pro Bono India and JSS Law College, Mysuru. As we wrap up the second day of our training session, I would like to take a moment to express our sincere gratitude, a heartfelt thank you to Dr. Muhammad Umar sir for another day for insightful learning. Your expertise, patience and engaging approach have made complex topics much easier to grasp. To the organizing team, thank you for your continuous efforts in the managing the session seamlessly and keeping everything on track. And to all the participants, your active participation and enthusiasm have truly made this day productive and interactive. Let us carry today's learning with us and look forward to another enriching session tomorrow. Thank you all once again.
Thank you.
Thank you.
Thank you.
For
Thank you
Umesh,
very
sir.
much.
Thank you. Thank you, Kalpesh ji.
Thank you.
Thank you so much. Thank you so much. And congratulations to JSS Law College, Mysuru, and you, madam, for taking the lead, and Professor Kalpesh for being so active. And perhaps we all draw inspiration from Professor Kalpesh about how radical and in a good direction the positive change in legal education he is bringing. So congratulations to the entire team.
Thank you, sir.
If you want to connect with us on LinkedIn, I am sending you the link in the chat box. Feel free to connect. and I would be most happy to respond for any query that you might have. Take care, everyone. Bye-bye. See you.
I would also acknowledge the presence of Senior Professor Nagendra Murthy, sir, who is a backbone for this program, sir. He is there online
Right.
joining.
Yes, so congratulations to Professor Nagendra Murthy also. And because of the leaderships like this only, we are able to organize programs like this. And let me tell you one thing, and I hope all of you would agree, that organizing a program in a hybrid mode is not an easy task. So I understand how much of logistics it must have taken for Madam and Professor to really get all of this together and have more than 100 participants over here. So all kudos to the students, to the teachers, to the professors, to the organizers for pulling this off. I have seen many programs getting cancelled because they are not able to understand how hybrid would work. But you have done this, so kudos to you.
Thank you, sir.
Bye bye. Take care. Bye bye.
Thank you.